could be some pending legislation or legislation that's being represented in states that have successfully been able to shut down initial attempts to put this type of legislation in place. And this, again, is a resource out on the website. We keep this map updated, and certainly it's something you can go into our legislative center if you have an interest in monitoring, and you can take a look on a state-by-state level in that center to get more details about either your state or bordering neighbors that you may have interest in watching. So with that, the issue at hand tonight is talking about the themes and the proposals of the FCC. So I'm going to turn to my counterpart, Angelina, now, who's going to give us a walkthrough of what the material looks like that's going to be discussed tomorrow.
Thank you, Stacy, and thank you everybody who has joined us this evening. I really appreciate you taking time out of your evening or afternoon for those of you on the West Coast to have this conversation. As Stacy mentioned, as Angela mentioned, I'm Angelina Panettiere. I'm the Principal Associate for Technology and Communications at the National League of City, or NLC. For those of you who aren't familiar with NLC, we represent the more than 19,000 cities, towns, and villages of all sizes across America. And in addition to conducting research on trends in municipal government and providing some assistance to cities on best practices, we also advocate on behalf of all cities here in Washington, D.C. And as part of my work, I work with city officials on our Information Technology and Communications Committee, which sets our organization's policy positions on telecommunications topics and takes the lead on lobbying on behalf of cities on these issues. And I see a number of members of that committee on this webinar this evening, so thank you all for being here. I also wanted to mention that if you're on this webinar or listening to the recording and you're either an elected city official or you serve in a senior staff capacity in a city and you're interested in these issues, and your city is a member of NLC, you can apply to serve on the Information Technology and Communications Committee. Applications are open right now and will be open through November. You just have to visit our website, www.nlc.org. And I'm happy if you get in touch with me later to answer any questions about that. So most of you are probably here on this webinar today because of the action that the FCC plans to take tomorrow during its September open meeting. If you're interested, you can actually watch that meeting online and view the full agenda by visiting the FCC's website. There are a lot of items on the meeting agenda, but the one that we're here to discuss today is the report and order and declaratory ruling on small cell wireless facilities siting. The order is very extensive. It's more than 100 pages long, but it's organized around 4 major themes that are going to impact local governments. And I'll walk you through them and what that might mean for your community. And something that I think is important to keep in mind here is that the entire justification for this action is based on the FCC's conclusion that any reduction in profits caused by administrative costs on wireless providers are, legally speaking, a prohibition on the provision of wireless service. And they say that's what gives them the authority to preempt state and local governments here. And I think that's a pretty shaky legal argument and a terrible precedent. And I think it's one that we need to challenge, not just in courts of law, but also in the courts of public opinion, working with your own constituents and with folks that you know in the community. So the first major theme of the order is increasing the access that wireless providers and tower companies have to public assets. And that includes both publicly owned structures like municipally owned poles and also the public right-of-way itself. So the proposal creates or changes some key definitions of terms, including what small cell wireless facilities are for the purposes of this order, and also changing the definition of what co-location is to be much broader than it has in the past. Small cell wireless facilities are actually defined as being fairly large. This includes not just a 3 cubic foot antenna, plus an additional 25 cubic feet of equipment on a pole of up to 50 feet or 10% larger than adjacent or previous structures. And a little bit later in this webinar, you'll get to see a visualization of what that equipment cubic feet amount looks like when it's compared to a person. But I'm also concerned about the definition of co-location. Instead of limiting it to existing wireless structures, which is how it's previously been defined, it's now going to be defined as placing an antenna and its equipment on any structure, whether that's an existing wireless pole or whether it's City Hall. And this matters because the shot clocks are shorter for co-locations. So you can see from these photos that small cells, by this definition, can be pretty obtrusive in your streetscapes if they aren't designed well. Those equipment cabinets, whether they're on the pole or ground mounted, can be pretty large. And these aren't the so-called pizza boxes that wireless providers have promised us. There's also no limit in the proposal on the number of antennas on a given site, so you could potentially see them studded all over a pole. The second major theme is important because it's about streamlining. As I mentioned, the definitions are significant because of the new shot clocks that hinge on these definitions. The proposal creates 2 new shot clocks just for small cell wireless facilities. The first one is a 90-day shot clock for new structures, and then a 60-day shot clock for co-locations. And as we just discovered, co-location now means attaching to any existing structure, even if that structure wasn't zoned or designed for holding wireless equipment. This also matters because back in March, the FCC eliminated federal environmental and historic reviews for small cell facilities. And at the time, they said state and local review would be sufficient for managing these sensitive locations. Well, now the onus would be on these same state and local governments to complete the review in a shorter, potentially much shorter time frame. And the shot clocks start as soon as an application is submitted or when mandatory pre-application processes begin. And that's regardless of whether the application is complete. So communities would have to notify the applicant within those first 30 days after it's submitted if they need more information and they need to pause the clock to get it. And if local governments overrun these shot clocks, providers are going to have the opportunity to seek expedited relief in court, which could mean forcing the local government to approve the application, even if that review hasn't been completed. Now, I will say one bright spot in all of this is that the FCC at this time has chosen not to impose a deemed granted remedy, which would mean that all applications that run past the shot clock would have been automatically granted. However, the FCC did note in their proposal that they will impose it if they see the need, and providers have definitely been agitating for it. The next part of the order, and the one that's probably been generating the most news and interest, has been the fee caps imposed on small cell facilities. This has been a major goal of the industry, and we've seen it on a lot of the state bills that Gina earlier discussed. There are 2 major parts to this. The first one is application fees, which would be limited to $500 for up to 5 sites, and then $100 per site for each subsequent site. The second is recurring fees for sites in the rights-of-way, which are limited to a reasonable approximation of a local government's objectively reasonable costs. And hopefully you can hear the air quotes in my voice that mimic the quotes around those phrases because they're not defined particularly well, and this is going to create a bit of a problem for cities. The FCC has also created a sort of safe harbor assumption of reasonableness for that because of this vagueness at $270 per site per year. This also prohibits assessing any fees that incorporate any cost not related to the rights of way, and the provision on objectively reasonable cost explicitly calls into question the reasonableness of consultant costs or contractor costs, which will probably raise alarm bells in particular for small communities. It also doesn't have any provision on grandfathering existing agreements. And most of those agreements have fees that are higher than these amounts or might include non-cash components or direct their fees to something other than rights of way management. This proceeding also would not replace your state laws. So if your state has already imposed harsher limits, you get to keep those limits. It's sort of the worst of both worlds. Now I'm going to turn it back over to Gina for a bit of an analysis on the financial impact that these fee caps are going to have on communities. And I'm sorry, Angela, not Gina.
That's all right. Before we do that, there was a question going back to something that you just covered, Angelina, and it was, does the FCC rules apply to public structures in the public right-of-way or public structures on any public property? And I know if you want to touch on that question now before we head into this section.
Yeah, that is a great question, and I would actually need to dig up a copy of the rule again because parts of it apply to all small cells and parts of it only apply in the rights of way.
Great.
I
So we'll
believe
take,
that the fee limit is on the rights of way, but we'll double check on that and let you know.
great. So I'll capture that question as a follow-up. So just saw that popping up along the way. So to Angelina's point, the impact of the reduction in fees is pretty dramatic, particularly when you look at it across the country and forecast it across the next 20 years. And so the slide that you see now is showing you the reality of the situation with the aggressive fee capping that's taking place. We liken it from our perspective as a colossal subsidy to a very trillion-dollar profitable industry. And it's a play to make a massive land grab to get those public assets as quickly as possible with as little out of pocket as possible. And so what you see here on this graph is an estimate of the revenue loss that will happen. The green line represents the potential revenue across the country with your publicly owned assets. And we advocate for fair market value pricing for those assets. And we talk about this a lot because, you know, fair market value offers the ability to fairly price your assets according to your geography, where you are. I heard someone recently use this analogy that an apartment in downtown San Francisco is going to cost more than an apartment in downtown St. Louis, for example. And so you can expect that assets have more value to them when they're in those dense urban NFL market tier one cities where they're looking to more quickly deploy this type of technology. And what we see, and this is a very fair and conservative average, is on average, most light poles, which is what they're primarily after, go for around $1,600 to $1,800 per pole per year in generating annual revenue for your city. With these proposals, as she just covered, that rate goes dramatically down to $270 per pole per year. And so you can see the revenue gap on the slide as we allocate it out across the next 20 years. And we base this looking at all 50 states with roughly about 840,000 small cells being deployed over that time period. And again, that's pretty conservative, but the impact on the revenue, I don't have to read the number, you can see it on the screen. It's dramatic. And so that's a cumulative loss of revenue across the country. And states that are already under regulation, in the 20 states that have passed small cell legislation, to Angelina's point, the insult to injury is if you were in a state that perhaps has legislation that now, you know, keeps you at $100 cap per pole per year, you don't get the opportunity to move up to the 270 that's now being proposed. And we didn't even factor that into this equation, just strictly looked at the 270 across the country, and it causes that major revenue hole that you see illustrated on this graph. The other thing that I would offer to you is we've modeled this across the states. And so if you are someone who has grave concern about this impact to your revenue, please feel free to reach out to me and we can provide you additional detail at a state level to illustrate the impact that it would have within your state walls. So Angelina, I'll hand it back over to you to go through number 4 on the list.
Thank you. So the fourth and final major theme of this order is placing some limits around local design and aesthetic review of small cell installations. And in the order, the FCC imposes a 3-part test on local requirements. First, they have to be reasonable, they have to be comparable to requirements for other rights-of-way users, and they have to be published in advance. We'll talk about this a little bit more, but this provision can be both used as a tool by local governments to establish some protections for their residents and streetscapes if you're working proactively, and it'll probably also be used to challenge local requirements by providers. Because there's no definition of reasonableness provided by the FCC in the order, providers are almost certainly going to want to challenge some of the local requirements that are imposed on them at some point. And this will end up being defined by courts or future rulemakings. They also wrap undergrounding into this. So for those of you hoping to require undergrounding of equipment or backhaul, you need to start thinking now about how to write those requirements in a neutral manner, but also be prepared to face challenges. The providers think those requirements are unreasonable on the basis of cost. Remember, I mentioned that a major underpinning of this order is this idea that any reduction in profits is a prohibition on the provision of service. So providers are going to make the argument that if they need to underground equipment or backhaul, that this is too expensive and this is a prohibition on the provision of service. So, it's important that you look at the requirements that you have now and figure out ways to sort of neutrally apply them across multiple utilities and users of the rights of way. And again, as I promised, we do have an illustration of what these equipment cabinets might look like in terms of size. You can see on the left-hand side a model of what that number of cubic feet might look like in real life. And you can also see some bad installations. This is what we're trying to avoid. We've heard challenges on everything to cities' requirements, from decorative pole design to being required to just paint equipment a particular camouflaging color. And as you can see, there are some really terrible installations out there. If you want to avoid the worst of this in your communities, you'll have to think through what kinds of objective design standards you can craft that are going to prevent junky looking poles and huge cabinets that are sitting in front yards or on sidewalks, and then be ready to defend them. Which brings us to our next point. I'm going to hand it back over to Angela to talk about the enormous amount of dissent and protest that we've heard from cities on this.
Yeah, and one note is a great segue, that picture. As Angelina mentioned at the top of the hour, that certainly shows you that we're not talking about something that's the size of a pizza box, a backpack, or a briefcase. It's significant what the definition of that small wireless facility is. And it's also significant to know that, cities across the country are voicing concerns over this matter. And it has happened so quickly. There hasn't been a lot of time, but the time that we have had over the last several weeks since the docket opened on the FCC, cities have become very vocal, and this is so important. We as a company host small cell legislation webinars on an almost a weekly basis, and I always try to provide my counsel to cities that your voices matter, and banding together within your state and forming coalitions to make sure your message is heard is so critically important to what's happening right now in the public rights of way space with the wireless industry. And what you'll see here on this slide is just providing you some snapshots of commentary. So I can make an assumption. If you're on this call tonight, you're probably wanting to learn more, wanting to understand what the impacts of this act would be, or these mandates would be if passed. And what do I need to do? Anyone else upset? Is it just me? And the answer is yeah, there's a lot of volatility when it comes to this issue. You'll see here that, national organizations, NATOA, NLC, NACO, the U.S. Conference of Mayors, et cetera, have all come out publicly saying that this is not the way to implement policies to meet local needs. Local governments are in place because they understand the uniqueness of their community and the expectations of their residents and their taxpayers. And so it's critically important to keep that local authority in place. One of the things I stress every time I'm in one of these webinars is that, we all want 5G services. We want to deploy the technology that will enable us to become smart cities, but we want to make sure we do it in a fair and balanced way so that it works for both the industry and the local government. And ultimately, the taxpayers, who right now are the ones that are going to be footing much of this bill, should these things be enacted. The other piece of this is that, it often gets overlooked, but local governments have to work to negotiate agreements with more than just the wireless industry when it comes to the public rights of way. And so any decision that prohibits a municipality's ability to define what kind of services or what kind of management they want in their public rights of way is a real threat. And it's a problem because it presents issues in management across the board in your public rights of way. And you can see some of these concerns represented not just from urban cities across the country who stand to benefit the most from small cell deployment, But also, this applies across the board to rural cities and places where we're still wanting to bridge the digital divide. There's nothing in the declaratory rulings and orders being put forward tomorrow at the FCC, nor has there been anything in legislation that's been passed in the 20 states that in any way defines or guarantees the responsibility of the industry to build out in your unserved or underserved areas. And that's the other big gap here. There's been a storyline that, this will help bridge that digital divide. And by lowering the cost of doing business in urban America, that will enable carriers to better expand more affordably in rural America. And we've seen no evidence of that. What we have seen, as you can see here out of Minnesota, is that this is really putting the burden of small cell deployment onto taxpayers instead of an industry that is extraordinarily profitable. Further, you can see some additional quotes coming here from around the country. And, San Jose has really been a leader in this space. They came out earlier this year with agreements that even, Commissioner Rosenworcel at the FCC deemed them to be model agreements. Even the industry at the table involved said it was great business until they realized that that conflicted with the policies that they're trying to promote nationally across the country. And they immediately came back and went to the FCC and said, wait a minute, we don't consider these a model. And we actually do, because what was important that happened in San Jose in the leadership position that they've taken on this type of legislation and mandate is that they were able to sit down and successfully negotiate a deal that worked for City of San Jose. It enabled a digital inclusion fund so that they really could start to address their underserved population, which was, one of their key goals. Across the board, not only are you seeing cities go on the record, hundreds of them actually have been filed at the FCC with letters on the record expressing their concern with this action. But we're also seeing, some industry experts like Blair Levin who've put out some very rational articles, and he comes from an FCC administrative background and can really look at this objectively and provide insight. And he deemed it himself that this was not the right part of work for the FCC to step in and mandate this across the board to states. And it really does, cause all of this work really comes to local governments are going to bear the burden and the cost. And there really isn't anything, as he said, that comes back as a guaranteed benefit from the industry. We have many other examples, and I'll mention again, if you do go out to our website, we try to blog daily all relevant articles that are coming out, and there's been quite a bit of coverage increasing since last week. If you look, you can find those articles on our resource tab on our website if you're interested in tracking them or you'd like to forward them. Blair's is certainly out there, and there have been a few others in the last 24 hours that have also come out very publicly with positions against this type of mandate. So kind of having said that, I'll pass the baton back over to Angelina, because right now you're probably wondering, well, what am I going to do? And she's going to talk to you a little bit about what those next steps should look like.
Yes, I'm a bit of a Pollyanna, but I like to end things on a high note after we've filled you with despair about preemption by giving everybody something to do and to fight with. And I want to echo what Angela said about the amount of advocacy that we've seen on this issue. It's truly been extraordinary. Earlier this week, Commissioner Carr, who's been spearheading this effort at the FCC, put out a press release claiming that dozens of local officials supported the preemptive proposal. And I think dozens is a bit of an exaggeration. There were a handful of local letters in the docket, but there have been hundreds of local letters in the docket opposing this move. We've also had over 600 local officials send letters to the Hill opposing the Senate bill. So this is definitely something that local governments have been successful in getting on the radar here in Washington, D.C. And in fact, this is hot off the presses, but just this afternoon, Congressman Jerry McNerney from California and 8 other members of the House Energy and Commerce Committee sent a letter over to the FCC objecting to the order on behalf of local governments and asking them not to vote on it tomorrow. However, in all likelihood, it will be approved at tomorrow morning's open meeting. So that's why we're mapping out a game plan to fight its implementation. And we'll be calling on all of you and all of NLC's members in the coming weeks and months to help us on these efforts. And we're also here to help you. So the first step in this process will be filing a petition for reconsideration with the FCC. And this is an administrative measure asking the FCC to withdraw its order and address the concerns that have been raised by NLC, by SmartWorks partners, and by the hundreds of other groups, governments, and individuals that have put comments on the record objecting to what the FCC is doing repeatedly over the past year and a half. Assuming that's not successful, the next step in the process is a legal challenge. Now, I will say that I don't know which parties are going to bring what are likely going to be multiple lawsuits, but it is very likely that a number of cities and organizations will do so in multiple courts. And if NLC isn't a direct party, we will support the cities that file suit with amicus briefs. And there are a number of legal arguments that people can make about this order. It represents a taking in constitutional terms. The FCC did not sufficiently consider the impact on small governments, which they need to do as part of their analysis of impact on small entities. And the FCC's statutory authority just does not extend as far as they want to stretch it for this order. In an ideal world, one or more courts would then grant an injunction on the order. But finally, we can push Congress to use its Congressional Review Act authority to overturn the order. This is why it's so important to keep your members of Congress in the loop on your objections on this issue to provide education. This is unlikely to happen before the election, but the lame duck period or early in the next Congress would present us with an opportunity. If you haven't had a conversation with your congressional delegation about issues surrounding small cell deployments, about this ruling, about what's happening in your state, I encourage you to do so. If your city has passed a resolution or sent letters, send copies to your offices. Because right now there is an enormous amount of money and lobbying moving around on the Hill by the wireless industry, and they're not getting a comparable amount of feedback and input from their local officials. So it's really on all of us to try and close that gap a little bit and provide those members of Congress with the ability to oppose it. However, your communities should definitely still be working to get prepared. I don't think any of the steps included here are exclusively due to this order. I think they're just good practices for people to engage in. So first of all, it's important to get up to speed on the technology, and NLC recently published a municipal action guide on small cell wireless technology in cities. You can see the URL for it there. You can download it for free on our website. And this provides a layman's guide to what small cell technology is, how it fits into the ecosystem, what it's used for, things to keep in mind as it's being deployed in your community, and approaches that other cities have taken to dealing with state preemption, to dealing with providers, to coming up with innovative solutions. Next, it's important to update your local ordinances and processes. You want to get things as consistent, predictable, and efficient as possible for your staff and for applicants. And you want to prepare your own documentation on how you structure fees and requirements to be ready for any formal or informal pushback from providers. This also gives you some time to figure out how to incorporate your residents in this process, because I know a lot of communities have some sort of public advisory process, community input, and the sooner you can do that, the better. This also gives you some time to figure out how to communicate about the changes, whether they're changes that your community is deciding to make or changes that are being forced on you by the FCC. A lot of communities have seen concern from residents either on aesthetic issues or radio frequency emission health and safety issues. And if you can proactively address that and incorporate your residents into your policymaking process, hopefully that will help you get ahead of some potential pushback when you're in the application process with providers and in the actual deployment process. And then finally, get ready for application and rights-of-way fee challenges. I think the two main places that providers are going to want to challenge you and are enabled to challenge cities by this order are on aesthetic requirements and fees. And I can't imagine that providers are going to go after every single locality on these two issues, but they definitely will use these new tools in some places, regardless of what agreements are in place. And you need to prepare for that eventuality. So make sure that you have documentation and accounting for your expenses, make sure you understand how those two things relate. And if they don't relate, if you have something based on market rates, any research that you have, or an explanation of what that money is doing will be valuable if you need to justify your actions. And hopefully for most communities, if they have an agreement in place with a provider and it's working for both, they won't immediately be challenged. But I think it's important for everyone to be prepared for the worst and hoping for the best. And before we hop over to the summary, I see Mayor Resnick's question about the petition for reconsideration. I believe it would stay the implementation of the order. There's also been some discussion about the effective date of the order. Right now, the draft of it includes an effective date that's 30 days after the publication of it in the Federal Register. And we and many other people have raised the point that that is entirely unreasonable to expect any local government to turn things around that quickly. Especially with smaller communities, their councils may not meet that frequently, or they may not legally be allowed to change things that fast. And I'm hopeful that that at least will be heard. I think that's fairly unobjectionable, especially as we're headed into hurricane season and winter, where there won't be as much deployment. And I'm optimistic that that will be changed, but we will find out soon. And with that, I will hand it back over to Angela to wrap things up so we can move into our Q&A.
Yeah, so appreciate the questions that have already popped up, and we'll open up that Q&A in just a moment to kind of just bring us back to what we've talked about. You know, from our viewpoint, this battle of small cell deployment and the race to win 5G, that's the messaging that's out there, is not something that's going to go away anytime soon. We think local control is going to continue to be challenged. And that's why we outlined at the beginning of the presentation kind of that three-pronged attack that's been taking place, so that you can see how all these pieces come together. You know, as we said, the most important point is that cities across this country, you have a voice, and right now is the time to leverage your voice with your local legislators to make sure that they are well educated on these issues and how they can impact you at a local level. You know, while we hear a lot, the word streamline is constantly out there when it comes to any kind of small cell deployment. In many ways, we think what the FCC is doing, and Commissioner Rosenworcel said it herself last week in a panel with Politico, we think this is actually going to bog the deployment down because of the pending and threatening of legal action to the actions that the FCC is most likely going to take tomorrow. So while it's being billed as this effort to accelerate and streamline the process, we actually think it's going to take a little bit of a step back because of the legal challenges that will be mounted. And those challenges, as we've outlined today, are warranted when we're talking about diluting cities' ability to gain fair market value for their publicly owned assets and restricting your design controls. All of those things are things that have to be addressed in a fair and balanced way. And then finally, you know, we've talked a little bit, we showed you some of the cities that are, you know, going on the record that are against this policy. And again, it's really important that you reach across your state and gain partnership and making sure that you're educating your state legislators so that they understand the realities of these types of mandates on local governments. And we're happy to help you. You know, we'll be distributing these materials out after the end of the call. We have templates available for letter writing campaigns and things of that nature that we're happy to share to make sure that everyone is making a clear picture within their state walls as to what this type of legislation and these types of mandates can really look like at the end of the day. I just saw a question, and so I think I'll go ahead and transition us over into the Q&A portion of the program, and many of you are already entering things in the chat box, so we'll get to them as quickly as possible. So I'll start with a question we just had. Can we discuss the impact in states that have small cell legislation already in place other than timeframes? Great question. They have similar impacts in the small cell legislation and what we've outlined here today. So it limits their ability to control their aesthetics in their community. It also dramatically, for them, one of the big things that's been proposed and passed in the 20 states that have small cell legislation is this combination of a more aggressive shot clock. And when I say more aggressive than the shot clocks that are already in place from the FCC. So, for example, you normally would have 30 days to look at an application and deem it complete or incomplete. But the small cell legislation that's in place now, for the most part in the 20 states, allows you only 21 days to review an application and deem it complete or incomplete. And the problem with that is, as they push for more aggressive shot clocks, and Angelina mentioned this at the top of the hour, they're allowing for bulk applications in those states that have small cell legislation. And in a bulk application, what that means is one application can house anywhere from 20 to 25 individual small cells that they would like to deploy. And the problem in the states with the legislation is that if you become overwhelmed by reviewing that number of small cell locations in one application and you miss the shot clocks, those states are under what's called deemed granted. And those applications can be automatically approved without going through the proper vetting processes that you have in place, to make sure that anything that's in the public right of way meets all your public health and safety concerns and things of that nature. So in some ways, the states are going to end up, the ones that have this legislation, with some more aggressive standards than what we've even outlined here today from the FCC. The problem is the other 30 states who don't have legislation in place are going to be mandated to follow what the FCC most likely will pass tomorrow. So the next question I see is, how can smaller communities leverage and contribute to efforts by cities? And I think that's a great question, because where we've seen states become successful in battling small cell legislation, California being a great example, they really made sure that they went out to all cities and towns of any size and educated both the residents and their legislators so that they could all converge on the Capitol in making sure that they were aware of the impact that this type of legislation would have. And so forming those coalitions across your state are really important. Angeline, I don't know if you want to weigh in on that one as well.
I do. I'll put in a plug here for engaging with your state municipal league and also with the National League of Cities or the U.S. Conference of Mayors or National Association of Counties, depending on what is relevant to your situation. We have all worked to try and activate cities, to mobilize them, to provide cities with resources such as sample comment letters or sample letters to send to Congress, along with these resource guides. And honestly, using those resources to communicate with your legislators and with policymakers is one of the most impactful things that you can do, especially if you're in a community that's a rural community. There's been a lot of interest at every level of government in expanding broadband access in rural areas. I don't think we've necessarily found any great policy solutions, but legislators are extremely sympathetic to rural issues right now. And articulating that and making sure that they understand how this would impact you as a small or rural community helps to tell that story. You don't have to have a lot of expertise. You don't have to be a lobbyist or have a legal degree. You just need to be able to tell the particular story of your community. What is it that makes you special? What are you worried about? How are your residents reacting? It's those kinds of anecdotes that put a face to a name that really convince people. And that's what will help us successfully fight back against a lot of the big time wireless industry lobbying that we're facing.
Great. So the next question I see in the chat box is, will the FCC order allow carriers to nullify, alter pre-existing cellular equipment placement agreements on city structures, such as water towers? Angeline, does the NLC have a viewpoint on that right now?
Yes, so the order explicitly does not grandfather in existing agreements, and we've had a conversation with Commissioner Carr about this. It was not their intention to grandfather in existing agreements. So the way it would work is it wouldn't immediately nullify your agreement, but providers would be able to challenge portions of that existing agreement that aren't in line with the order. So for example, if you have negotiated annual fees that are higher than that 270 safe harbor, they could challenge that, and the onus would be on your community to justify those rates. Similarly, if you've negotiated equipment deployments, fiber strands, anything like that, they would be able to challenge that because that would not be allowed under the agreement. But the FCC isn't going to come out and put you in FCC jail. It'll really be on the providers to start the process of overturning the agreements that you have in place.
Great. And so the next question I see is, will we publish and share the webinar slide deck after the webinar today? And we will, along with a recording of this webinar as a resource also. So next question up, the Indiana legislation allowed a very small 7-day window to designate sensitive areas as underground areas. Is there anything in the FCC proposal to provide similar protections for residential and commercial areas where they've already paid to have utilities undergrounded rather? And Angelina, I know you touched on this a little earlier in the presentation. Do you want to expand a little bit on that?
Yes, so there's nothing explicit in the order about undergrounding other than to note that undergrounding may be unreasonable. So they don't explicitly say that all undergrounding is unreasonable, but they seem to be operating under this assumption that cities are trying to place antennas underground. They don't address anything as specific as requiring the undergrounding of backhaul or equipment cabinets. So I think we're going to see some challenges to that. The other part of your question, they did not distinguish between different areas within a city or different kinds of zoning designations. So, for example, the size requirements and that 50-foot height limit, those apply regardless of whether you're in a single-family home residential neighborhood or in a warehouse area. It'll really be up to your community to articulate the differing requirements between areas in a sufficiently neutral way, so that when applicants come to you, you have those designations in place. But there's no federal protection on that front.
Great, thanks. So next question I see, and I think this is a great question, what are the immediate practical effects of the declaratory ruling? And I think it's interesting because, as Angelina alluded to a few moments ago, they are expecting this to go into effect 30 days after it's entered on the Federal Register, which clearly doesn't allow appropriate time for cities to make these adjustments. So Angelina, what's your position in terms of, what next steps do you see? You've outlined today what they need to start thinking about, but do you see any other immediate practical effects coming as a result of the ruling being passed tomorrow?
Yeah, and I feel now, since I didn't already, the need to preface all of this with the fact that I'm not an attorney and this is not legal advice, and you should really talk to your municipal attorneys about this. But in my crystal ball, I'm expecting, as I mentioned, a series of challenges to be presented, hopefully something that will stay the order. And we've also asked the commission to stay the order and hopefully extend that 30-day window of the effective date. But what I'm anticipating after it becomes effective is that we'll probably see providers take a targeted approach to challenging cities on their existing agreements, or pushing cities on agreements that haven't been finalized yet. For those of you who dealt with certain tower companies in the last couple of years that were sending out threatening letters or claiming that the city had legal obligations to provide them with this or that, I think we're going to see more of that because sending a lot of letters to cities is a very cost-effective way to get what you want if the city is concerned about having to deal with the expense of a lawsuit. But I think it's important that people not be intimidated by that and be clear on what their rights actually are as a community. You can still impose aesthetic requirements. You have to justify what you're doing, but you theoretically could assess annual fees more than that $270 cap, but you have to have your paperwork in order. But I think to answer your question more briefly, I think we're going to see a wave of threatening letters followed by maybe some targeted legal challenges. I suspect that the larger cities that have done some of the most innovative things around small cell deployment, such as San Jose, are probably going to see the challenges first because I expect as the people most out front in this, providers are going to be eager to make an example of them. I think a lot of providers that were happy with the agreements that they signed a year ago are maybe not going to be so happy in 6 months when they have the opportunity to revisit them.
Yeah, and I would add one other point too, and as we've been out, providing education and awareness on small cell legislation, one of the things I like to reinforce is that if you have your house in order, that certainly will make these types of scenarios more easily dealt with. But in the interim right now, if there is a stay that is granted, it's very important to take a step back and look at your overall broadband master planning to make sure that you're addressing some of the things, the design aesthetics, and the things that are within your control so that you are more prepared to handle what we believe will be an onslaught, in those key targeted cities. And so, that certainly is something to take under consideration as well. And then I see another question coming in. Has there been any discussions with wireless providers about a potential compromise related to fees? Or is it possible for them to agree to a fee above the FCC proposals? Do cities have leverage to negotiate a higher reasonable fee per pole per year? So, the proposed negotiation period, I think, is now, come to a close. What we saw in the 20 states that have passed small cell legislation was, and primarily it was AT&T's lobbyists that went in sponsoring, presenting the legislation within the states, and they almost had a defined toolkit. So you saw 5 very consistent themes, and of those themes with the fees, the range of fees that were quote unquote negotiated within those states that have the legislation ranged from as low as $20 per year per pole to as high as about $200 per year per pole. Um, and I'll certainly let Angelina weigh in on this as well, but right now what the industry is after is a flat fee, and that's that 270. And when these mandates go into effect, there is no longer negotiating for fees. They're going to hold you accountable to that $270 per pole per year. And Angelina, I'll let you weigh in on that as well.
Yeah, so the order does technically allow fees to be higher than that. They call the 270 rate their safe harbor fee. They assume that any fee that is $270 or below for that annual recurring fee is reasonable. Um, but technically you can go above that. The requirement, though, is that any fee above that or inclusive of that has to be a directly related reasonable approximation of your reasonable costs incurred in managing the rights of way, in managing that particular site. So a number of cities have raised the issue that $270 does not capture those costs. So if you can provide documentation of those costs to the provider, it's entirely possible that they'll be willing to work with you on this, especially if you're already an attractive market, if you've established a good relationship with the people negotiating in your community. But it's also possible that they'll decide that they think they have a case and will go and seek relief from a court. In which case, it's even more important to have that documentation available. Hopefully, any court looking at that would look at the FCC requirement, and if it were directly related to your costs of managing the rights of way, and that has been clearly articulated, would allow your community to assess that fee. But that doesn't mean that any fee above that $270 limit would be allowed. So for instance, this does not encompass market-based rates. If your fees are based on the market value of your rights of way, that will not work. It also does not encompass anything like the City of San Jose's Digital Inclusion Fund. That is not directly related to maintaining the rights of way, and so would not be allowed under the terms of this order. Now, the providers that have negotiated agreements with that city might just leave it in place, but they would have the ability to challenge it. So the FCC tried to make it pretty clear in their order that they would prefer, and providers would prefer, that cities and other jurisdictions only stick to this 270 number. But they did leave some room in there to allow for something above that. I think it's going to be an uphill battle, and so I think communities that are facing pushback from providers are going to have to make a decision about what is most worthwhile for them based on the size of deployments, based on other factors, whether they're able to deal with a challenge or not.
Great, thank you. So then the next question is, have we looked into towns like Petaluma or Mill Valley, and will this new legislation affect them? And so I think and Donna should know this, but I don't, I'm just going to admit, is Petaluma, California? If so, yes, this will go into effect for any of the 30 states that currently are not regulated. The 20 states that do have legislation in place would not be affected. So in California, thanks for confirming that, Don. In California, you would be impacted because you would be expected to manage to these new mandates from the FCC. The next question I see coming through, Florida law does not allow attachment on city utility poles owned by a municipal electric utility. Any idea if the FCC order would preempt that carve out in Florida law? Angelina, do you have a point of view on that from the NLC?
I can take a stab at it. And Mayor Resnick, you know as well as I do that I'm not an expert in state law, but you might want to follow up with the Florida League to see if they have a take on it. But my understanding was that it would preempt those provisions in state law. I know that they drew a lot of inspiration for this order from existing state laws, but as far as I know, the public utilities have been extremely concerned about this because it does not provide those kinds of carve-outs for them. And as effectively a local public entity, they would be subject to the same sorts of restrictions that local governments are in terms of the use of their property. And actually, that's a nice segue to the next question from Brian Gold about what about investor-owned utility poles. So this order only applies to public entities, state, local governments, public utilities, so it would not apply to investor-owned utility poles. I'm a little fuzzier on how the process works with those investor-owned utilities. So unfortunately, I don't have a definite answer there for you on how this would impact those, but we can follow up with you on that.
Great. And so then the next question I see is, are you able to explain how the FCC established the $270 fee? That is a magic question, wouldn't you agree, Angela? I'll give a point of view that I have coming from my experience on the BDAC. And so as a member of the BDAC, back in November, a rates and fees committee was established at the BDAC, and it was charged with examining rates and fees across the country in hopes that that group would be able to come back to the BDAC committee and make some recommendations on fair ranges of fees. Unfortunately, in our last meeting in July, the Rates and Fees Committee came back, and after having gathered almost 1,200 surveys of data points on rates and fees across the country, they were told could not utilize that data in their report to the committee due to some conflicts that were claimed to be non-disclosure related. And so I would encourage you, if you go out to the FCC website, you can find the BDAC page, and the published rates and fees report has a footnote on page 3 that alludes to that. And because that work was not able to be utilized, we were not presented with any types of average fee structures that could be a reference point. And so from my perspective as a BDAC member, I still remain gravely concerned that that committee was not allowed to complete their work and use the data that was gathered to provide a recommendation. And I very much, as a BDAC member, feel they jumped the gun in moving forward with a fee structure recommendation in CAR's order ahead of valuing the work of that committee. And there were quite a few members of both industry and those that had municipal interests serving on that committee that put in a lot of work that unfortunately looks like it's not going to have an opportunity to be fairly presented. And so I don't know how they got to the 270 because I was still waiting on the work of that Rates and Fees Committee to come back to us. And that's my perspective, Angelina. I don't know if you've got further that you would add to that.
Yeah, I have a bit of a bone to pick with the whole BDAC rates and fees situation. I agree with Angela's assessment of the situation. From what I understand, the data that they found pegged the market rate and the general average at a number much, much higher than the 270 number. But the way they articulate it in the order is that by looking at the existing state laws that Angela described with the range of about $50 to $200 per site, they thought that $270 was a very generous gift to local governments. I apologize for the extreme sarcasm, but we disagreed strongly with their assessment of the situation, and I believe that the reason the rates and fees report was not released was because it did not provide data that they wanted to use in this process.
Yes, and I appreciate, Janet, your sense of humor about maybe it was a typo. Yeah, I unfortunately don't think it was a typo. And there is another question, are the presumed, quote, fair fees relate to costs going forward once the equipment is installed, or does it include what can be charged in processing the applications? And there are some capping of application fees along the way. And I'm just moving to see if we can put that back up. But you can see the limits that they face on application fees here on slide 9 of the presentation. And so it's beyond just the capping of, the location, the pole attachment. They're also capping those application fees as well. And we saw that in the states that have the small legislation in place there. And part of the concern there, again, is when you're talking about bulk applications coupled with the reduction in some of these application fees, it becomes more of a challenge to cover your cost of doing business to vet those applications appropriately, and always been a concern of ours. Angelina, do you have anything else you would want to add to that?
Yeah, so I just want to sort of caution everybody about this idea of reasonable and unreasonable. I was flipping through the order while Angela was talking, and I'm just going to read you a little excerpt because I think it's really important to get an idea of how the FCC is approaching this. They say, thus, fees must not only be limited to a reasonable approximation of costs, but in order to be reflected in fees, the costs themselves must also be reasonable. Accordingly, any unreasonably high costs, such as excessive charges by third-party contractors or consultants, may not be passed on through fees, even if they are an actual cost to the government. If a locality opts to incur unreasonable costs, the order and the law do not permit it to pass those costs on to providers. So the FCC is really calling into question what can be included in that idea of reasonable. And unfortunately, they do not provide an itemized list of exactly what may or may not be included. They've left it very squishy. And unfortunately, I think that's going to open people up to a lot of litigation.
Yes, I agree. So I see another question coming through, and I am noticing our hour has passed very, very quickly. I've got about 3 after 6 Central. So I appreciate those of you hanging on with us still. I've seen a few that have obviously had to drop due to the time. So I'll make sure if you have some questions, go ahead and get those into the chat box. We'll try to get to those as quickly as possible. I see another question. Is there any possibility that the $270 recurring fee would be paid to the utility owning the poles? Our state municipal league representative indicated that is his interpretation. And that's an interesting question. I haven't seen it posed that way before. Have you, Angelina?
No, I haven't. And to be honest, I'm not entirely sure what the answer would be because, often utilities assess pole attachment fees, but localities also may assess rights of way occupancy fees, and I'm not entirely sure how the two would play together under the terms of this order. I don't know if the 270 would then become a cumulative cap, or if because they're two separate authorities, they would be two separate fees paid. I just don't know.
We'll take that back, Jana, and see if we can't get some further detail to come back to you on that. We'll do a little bit more investigating. So great question. Thanks for that. All right, so I'm showing us moving after 5 past the hour, and I am starting to see some of the questions and comments slow down in the chat box. So I'll start to bring us to a close. One, we are really thankful for Angelina's expertise and allowing us to partner with the NLC to bring this information out to you this evening. So very appreciative of that relationship and all the hard work that goes on with the NLC to make sure folks around the country are well educated on these issues. So appreciate all your time and input, Angelina, in helping develop the content for tonight's webinar. Also, just a reminder, we will send this out. We have recorded the presentation. The slides will be included in the follow-up to the meeting, as well as links to the small cell resource guide that Angelina mentioned earlier. And we're always available for questions. You know, I'm not really sure at this point when our next BDAC meeting will be, but I do always like to offer myself up because I do represent municipal interests on that committee. And so I always welcome your feedback for that along the way. So feel free to reach out if you have additional questions or feedback for me. And a reminder that much of what you can see, you can monitor on our website in the Legislative Center. We will continue to keep our blog under the resource tab updated as well with relevant articles as this is unfolding in DC tomorrow. So if we can be of any help in any way, please certainly don't hesitate to reach out to us. And Angelina, any closing comments from you before we close out this evening?
Yeah, actually, one last bit of news for everybody. I told you this is a moving situation, and while we were on this call, I got an email from Senators Schumer and Gillibrand. They sent a letter over to the FCC from the Senate side. So as I mentioned, people raising their voices and educating their legislators is making a difference. I do believe that we can fight this. So thank you all for all of your efforts. Please stay in touch with us, with your state municipal leagues, and don't hesitate to contact us if you have any thoughts or questions or concerns.
Great. Thanks so much, everyone. We certainly appreciate your participation tonight, and let us know how we can help you. Everyone have a great rest of your evening. Thanks so much.